says, got it? Please click it. But I also want to share our disclaimer first. Now, this session is intended to be informational and educational and does not constitute legal, medical, or financial advice. So you need to consult your legal, healthcare, or financial advisors for advice regarding your personal situation. AARP is not responsible for the consequences or anything that is AARP is not responsible for the consequences of any decision or action taken in reliance upon as a result for the information provided during this program. So now let's turn to the program for today. Everybody get started here. Bahar Geslin is a seasoned attorney with over 15 years experience in the legal field. And you imagine, ladies, 15, ladies and gentlemen, 15 years. She has a driven passion for life as an advocate. As a founder of her own law practices, she has spent the past 11 years specializing in trust and estates, helping families plan for their future to navigate complex legal matters with care and expertise. Now, beyond her legal career, Bahar is a devoted mother of three, juggling the joys of challenging motherhood with fulfilling her professional life. Now, when she's not in court, when she's not in court or working with clients, Bahar can be found exploring new destinations, creating delicious meals in the kitchen, or enjoying the energy of live music. With a deep love for traveling, cooking, and all things music, she believes in embracing life's vibrant moments by helping others secure their legacies for generations to come. Let's welcome Bahar.
Thank you so much, Joyce. You make me sound so interesting. I want to know this Bahar that you described. I'm like, oh, that's right. I do like to cook. Good morning, everyone, and happy birthday, Rosemary, and welcome. Thank you all for choosing to spend this morning with all of us and with me. I'm excited to talk about estate planning. It's something that I'm very passionate about, and I want to actually describe what that term means. As Joyce mentioned, I want to say again, I am an attorney. I'm a licensed attorney in California. However, this is not legal advice specific to you. Everything I talk about is going to be true and accurate as it pertains to California, but I know some of you are visiting or with us from other states, and some of you I saw are even bi-coastal. So that's exciting. You do need to check with your own counsel in your own state that can look at the facts and circumstances of your specific situation, because not everything I say is going to apply to you. So with that, I'm going to share my screen here. Give me a moment, please. Um, and we will look at, I have a little, just so I know some people like a visual, and and so I have that for you. All right. Can everyone see that? All right. So, estate planning. What does that mean? It's really a term of art, and it may mean different things to different people. And some people think, oh, estate, I don't have an estate. And they go, all I've got is just, right? Or I just have a house. I just have retirement. And they don't think of of themselves as having an estate. Well, everyone has an estate, every single person. It may be an estate that's made up of a lot, made up of a little, made up of debt. But regardless, it is an estate. And an estate plan is a set of legal documents. And I'm going to go through the major, the primary documents that make up an estate plan generally. And so it's a set of legal documents that let everyone know what happens if something happens to you. And often when we think about something happening to us, we think about death. But that's not, it's really a much broader spectrum. There's everything from nothing happening, right? We're living, we're going on today, to a temporary issue or capacity issue, to a permanent health or capacity issue. And then, yes, ultimately at the end of that spectrum is death and what happens to your estate, your assets and your debts after that. So it's a set of legal documents to say, what's the plan here? All right. In California and in many states, if you if you don't have a plan, and we need to act on your behalf, whether that's during your lifetime or at your death, and you don't put these documents together, then we're not going to guess what you wanted. No, we're going to have to go to court and get guidance on what that should be. And there's certain, you know, rules and regulations, and there are a lot of steps. This is a costly process. And then, as you may or may not have had experience with our court systems, it's very slow, especially post death, right? Somebody's gone. No one is in any rush at this point to take care of things. They're just like, all right, well, they didn't take care of business and we're going to take care of it for them, but we're going to take our time doing it because they're gone. So it can be very frustrating for families because they're like, what? I usually promise families that I'm working with post death. I'm like, this will be a slow process. What I can promise you is this will be slow. This will be frustrating, and you will often be upset with me because you think that I'm not doing my job, but it's the process. So what we're going to talk about. So that's all the bad news, right? Um, but we can avoid all of that. When we have a plan, it's written instructions, legal instructions to everybody about what to do, who's in charge, where's it going if something happens. Let's see. At the center of an estate plan is a revocable living trust. A trust is a document, very detailed instructions that say, this is who I am, right? If you're married, this is who we are. As long as we're alive, we're in charge. If something happens to one of us, maybe this is who we want to be in charge, often the other spouse. And if something happens, if we're incapacitated, this is who we want to be in charge of using our assets to take care of us. This is really a key piece. I'll talk about it again later, but um, I get so excited about saying this, so it'll be a little bit redundant, but it's probably something people need to hear multiple times. Um, Oftentimes people go, well, I have a beneficiary. I have a pay on death, a transfer on death, a beneficiary on this account. So you're telling me I need to go through this whole process and spend all this money with you? Ha ha ha. And the thing is that when somebody is named a beneficiary on death, that gives them access. It's true after the person dies, right? After you die. But it does not give them access during your lifetime. And so, unless your loved ones have deep pockets and they have lots of money to spend themselves on your care and well-being, or they don't mind, doing that, there's no way for them to access your assets while you are alive to take care of you. They would then have to go to court and get a conservatorship. So unless you do these documents, they can't use, you go, well, worst comes to worst, they sell the house. Okay, well, how are they going to do that if you don't set up um, all the documents for them to be able to do it? Also, you want to dictate who is in charge, not have a court do it, or for your loved ones to be looking around and saying, is it you? Is it me? Or worse yet, fighting. It should be me. You never showed up for mom. You never visited auntie. You, you were so mean. It shouldn't be you. And then this is where families start to fight. This is where people start to take advantage, feel entitled. I'm sure none of you have entitled family members or have witnessed this, but it's something I see. So, what is a trust? A trust is this document and it's just instructions. It's like, this is who I am. This is who's in charge if something happens. And these are their orders. This is what I want to happen. As long as I'm alive, my assets, whatever they are, as little or as much as they are for my benefit, general welfare and comfort, as long as I'm alive. When I'm gone, this is where I want it to go, right? Your beneficiaries. Maybe that's charity. Maybe it's your kids equally. Maybe it's your family unequally. Maybe it's your best friend. We have autonomy here, and we get to say there are a lot of countries and places where you don't have that autonomy. You actually can't uh, name your own beneficiaries. Like you have to name your kids, and you can only, it's complex, but you basically have to name your kids. That's not the case here. You can name your church, you can name your favorite nonprofit, and you can also share it with your friends. But if you do, it doesn't matter what you want in your heart if you don't put those wishes into a legal writing. Um, and a legal writing that's going to hold up and that doesn't conflict with anything. That's why it's so important to work with an attorney who really knows this area, because sometimes people will come to me with like, "Oh, I already drafted everything. I did everything. I'm going to give, 1% to this person, 2% here." And they have this plan, and I'm like, okay, well, that's great. It lets me know where your values lie and who's important to you. But let me tell you why, it's not a good idea to give, somebody 1% of your estate. Now, there may be situations where that is a good idea, but it's usually not. And maybe we'll have time to talk about why. So you create the trust. It's like detailed instructions. And in California, the reason why we're talking about a trust first is it's really the center of the estate planning universe. Um, if you own real property, okay, so that a house, land, condo, whatever, if you own real property, whether it has a mortgage on it or not, so it doesn't matter. So if you own even a reverse mortgage, if you have a reverse mortgage, you still need to have your property in a trust. Um, if you own real property or you have more than, oh, I changed this number last night. I'm sorry about that. It must not have saved. Excuse me, this $184,500 number is incorrect. It's more like it's $208,500. So let's just say $200,000 for ease. I just noticed that. Sorry. Again, you own real property or you have more than $200,000 in gross assets and you die and you don't have a trust, your estate automatically goes to probate, right? So we have these different court systems in California, and probate is one of them. You've heard of family, civil, criminal, small claims court, traffic court, bankruptcy court. We have probate court. And that is the world where things go when people meet that threshold and they don't have an estate plan. Or even if they don't have that threshold, but we need guidance on how to access the assets. More and more institutions, even though they shouldn't be doing it. I have a client whose wife passed recently, and there is not $200,000 in the account. There's less, but they're still asking for a court order that they are the executor or personal representative. It's like, okay, we don't need that. But oftentimes, the bank is concerned with their liability. They don't want to hand the money to the wrong person. They feel better if they have a court order. So sometimes they're forcing people to get court orders and go through probate, even if it's not required. So it's true, not everyone needs a trust-based plan, but most people I come across um, really would, it makes sense for them to have it because, again, there's this piece that often even other lawyers don't think about. It's okay, sure, you're not going to meet that probate threshold when you die, but if you have $150,000 and you need your loved ones to access it during your lifetime to pay your rent, to pay for your medical bills, then um, not having it in a trust is problematic. Now, some people may say to me, well, I'm just going to put that person that I trust as a joint account holder. Then again, I don't have, I can avoid you. Well, That may be appropriate for some people, right? They've got one kid, they're getting everything anyway, and it gives them access. Beautiful. But when you put one person on an account, they become essentially a joint tenant of that account. And that means they can take the money out at any time. So I'm sure you're not naming somebody you don't trust, but that does happen, right? And I have seen that. Like they took all the money out of my account. I only put them on, so that it was easy when I died. Well, I'm sorry, but that's just the case. And if you have multiple people that you want to be your beneficiaries after you die, and you put, let's say, one of your kids on the account, or, your one nephew on the account, they are a joint tenant of that account. That means that if they die, 100% of the money is yours. If you die, 100% of the money is theirs, and it does not get distributed per your will or trust. That is theirs. So I always say there are a lot of smart people that have thought of ways of avoiding this process of estate planning. And maybe sometimes it works out in their favor, but usually it does not. So pay now, pay later is how I look at it. Um, so when you create a trust, it is a very flexible document. Most people are a revocable trust is what's going to be important. There are revocable and irrevocable instruments. An irrevocable one means it's very hard to change. It kind of locks it up. But a revocable one means, if people have young children or young beneficiaries, right? Like you named your grandchildren as beneficiaries and now they're older, and you want to change what that looks like. Or maybe you named as your successor trustee, that's who's in charge if something happens to you, of distributing the money and using it to take care of you. Um, and maybe you named your nephew, right, or your best friend, but now your best friend is not in good health, or and you want to name the next generation. Well, you can very easily change that. So, and relationships change, right? People move away, people tick us off. We don't trust them. Relationships evolve, and so your documents will evolve with them. Let's see what else I said. They don't keep staring. Okay. I do want to go back to the trust and to one thing I say here. When you create a trust, you have to fund the trust. And that doesn't mean what? I have to fund it. I have to pay more money. No, it means that now you have to do the very important job of making sure that your assets are titled in the name of the trust. So if you have a home, let's say your name is Minnie Mouse, instead of the home being in the name of Minnie Mouse, it's going to be in the Minnie Mouse Trust or whatever the trust is called. Okay. That makes that lets everyone know that this asset is going to be distributed per the terms outlined in this document. So it matches. If you have a bank account, even if it's like an operating account, you get your pension paid in there, you get your retirement paid in there, and you're like, people say to me, it doesn't have anywhere close to $200,000. It's, I barely keep a balance in there. I get in and then I pay my expenses and still, it needs to be in the trust because um, oftentimes our main operating account, our main bank account, provides incredible information about what our liabilities are, what are like if somebody needed to step in and all of a sudden take care of you, they would know what your subscriptions are, where you were donating money, what things need to be canceled, what things you're signed up for. So it's very important to have that account in the name of the trust, even if there's not a huge value. Okay. The other, so really, center of the estate planning universe is the trust. Okay. One of the other documents is a will. I think everyone has heard of a will. It's a legal document that sets forth your wishes of how your property should be distributed after you pass. I want to say this clearly, and I'll probably say it a couple times. In California, if you meet that threshold of owning real property or having more than $208,000 in gross assets and you die, It is not sufficient to have a will. You must have a trust. The one and only way to avoid probate court in California is to have a trust. Okay. But we still create wills because they're usually pour over wills. They say, hey, if you want to know the disposition of my assets, if you want to know my wishes, look at my trust. It just is like an arrow. Um, Also, it's like a safety net. So if you create your trust and you put all your assets in there, which may sound arduous, but it's really not that difficult. And it's something that when you go to your attorney, make sure that's something that they're going to walk you through. Um, I can't tell you how many times I see that, oh yeah, my uncle, aunt, mom, dad had a trust. Nothing is in the name of the trust. Guess where we still end up? Probate court. It's a truncated proceeding. It's not going to be subject to all of these fees, but it still happens in court. It's still long. And guess what? You still have to pay an attorney to do it. So, um, oftentimes people say to me, oh, you are like double what this person down the road is telling me it's going to cost. Like, okay, well, what are they providing? So even if you get a quote from an attorney and it sounds a lot, make sure you're understanding really what they are providing and whether it's a comprehensive plan that looks at everything or not. So the will, I was giving an example of where the will comes into play, even if you have a trust, because you say, Bahar, you told me a will is not enough in California if I meet this threshold. So why do we have to have it? If you inherit something and right, you didn't take title to it. So you created your trust, you did a great job. You transferred to your house, you transferred to your accounts, all of that's buttoned up, and then you inherit something, and before you get a chance to put that money in the trust account or you forget, well, the will allows us to bring it into the trust in a truncated proceeding instead of it being a complete probate. Um, and Also, sometimes people get reverse mortgages, right? They reach that point in life where they really want to leverage the equity in their home to help them live. And so they get a reverse mortgage. And in that process, the house comes out of the trust. Well, this, if that happens and nobody notices, and then the person then dies, it allows us to kind of bring it back in. This is evidence that a judge is going to ask for to make sure that your intentions were for that asset to be distributed per the terms of your trust. Um, I wanted to give a little example of probate fees so that people get an idea. Um, a $500,000 estate, and probate fees are assessed on the gross value of the estate. Okay, so if somebody has a condo and it's worth $500,000 and there's a $400,000 mortgage on it, probate fees are not assessed on $100,000. They are assessed on the gross value of it, so $500,000. And those fees are about $30,000. On $1 million estate, which I'm in sunny, is it sunny? It's kind of sunny Southern California. Um, Home values in around here are very easily $1 million gross value. People have mortgages on them, right? Um, those fees are about $50,000 in probate court. So when you're getting a quote from your estate planning attorney and you're thinking, wow, this is a lot, know that if it's being done properly, it's going to avoid a lot of money, but also a lot of headache. These can take years to go through court. Okay. So the will says, what do you want? For those of you that really don't need a trust and a will is sufficient, this is where you're going to um, say what you want. A will is only valid if it's properly executed. There are very strict requirements in California and in most states, but again, I'm licensed in California, of what makes a valid will. In fact, in law school, it's a class everyone has to take and it's on the bar exam. So you know that it's an important thing, right? There are a lot of areas of the law that are not covered on the bar exam, but what makes a valid will is. And so I'm not going to go into what that is. because it really depends on the situation. But there are times where people are like, well, I can just write up this will. I'm just going to type it up on my computer. I've got a computer. And they type it up and they sign it, but it wasn't dated properly or it wasn't witnessed properly. Or what makes it a holographic will is that it has to be in somebody's handwriting. It can't be typed. So there are all these intricacies that you may think that you're doing it properly. And in fact, um, that the person then dies and it actually is not a will that's valid in court. And why that's important is because maybe you wanted your estate to be split 50% between your favorite, your church, and the other 50% to go equally to your kids or your nieces and nephews, right? Well, when your will is not valid, it's just going to go via what's called intestate succession, which is legal mumbo jumbo for your next of kin. And it's going to go to whomever that is. So they look at if you have, your spouse, your kids, then parents, siblings, nieces and nephews in that order. If you don't have one of those categories, and that may not at all be what you want. Just checking the time. Okay. So we talked about a trust being the center of the estate planning universe, and then all these other documents supporting it. Um, the next kind of suite of documents, set of documents, are what are the incapacity documents. The trust does deal with incapacity. So let's say your asset is a home, that home is in the name of the trust, you become incapacitated. That's a mental incapacity. So you can't make decisions for yourself. So who you've named as your successor trustee is going to step in and help out, right? They're going to make sure your bills are paid and they're going to say, okay, well, I need dad to to have care, and there's not enough cash to pay for the care, or there's not insurance to pay for it, so we need to do a reverse mortgage on the house, or we need to sell the house, or rent the house out and put them in a care place while they're recovering, or whatever the situation is, right? And so they're doing that using their their authority to do that is because the house is in the name of the trust and they are named as the successor trustee in the legal document. So again, it matches. And they've determined that you're incapacitated because two of your doctors have given them notes saying, you know, dad doesn't have capacity. That's how that works. There's a whole slew of things that need to be taken care of that do not pertain to the trust, right? The main things that go in the name of the trust are real property, investments, checking, savings. What does not go into the trust are um, life insurance, any kind of long-term care insurance, and retirement. So we're going to talk about that in a little bit. But the reason why I'm mentioning that with the durable power of attorney is because that is how this document works with the trust. Um, Last year, I think I did two 1 hour talks with Piggy Bank Essentials just on the power of attorney. So there is a lot there. Looking at the time, but just know that the trust works together with the power of attorney. One of them does not replace the other. One of them is not enough. Let me give you some examples of where a power of attorney would come in uh, when there is a trust and it's appropriate to still have a trust. So I said the house is in the name of the trust's name. Your successor trustee is going to deal with that for you. A power of attorney can allow your agent, which is the person you name, or your attorney in fact, to act on your behalf if you become incapacitated. Um, Sometimes a healthcare directive is also called a power of attorney for health. I'm talking about a durable power of attorney for finance, for administrative issues, okay? Not for health. We'll talk about that next in the next slide. So the durable power of attorney, let's say finance, but it's more robust than that. Discuss it will allow your agent to talk to Social Security on your behalf. Maybe you're now receiving Social Security payments and you need to direct those, or sometimes there are elections to be made, or your spouse died and now you need to make sure you're getting the spousal death benefit, or, you know, they can speak to your employer if you're still working. You need to change your healthcare elections through your employer or just through Medicaid or Medicare. They can talk to these agencies on your behalf. They can sign contracts. You need to be in a temporary rehab facility to recover from something. They can help look around for those and sign the contract for one of those type facilities. Maybe you have a rental unit, and this happened recently with a client of mine. Her mom was incapacitated, and the the renters would not issue the check to her, like hand the check to her, because they somehow knew that her mom was incapacitated. And so that's where the power of attorney came in. You can collect, you can settle obligations. So you know, your loved one is in, or you owe money to somebody and you need to keep paying them, they can write a check to that person on your behalf, signing as your attorney, in fact. What are other interesting things? You need to your house needs to be retrofitted, and they need to hire a contractor to put in some accommodations in your home to take care of you. They might do that under their authority as your power of attorney. And retirement. So remember, the trustee is going to deal with trust assets. And this person is, 95% of the time, your successor trustee is the same as your attorney in fact or agent in your power of attorney. Okay. But they're two different documents that are triggered by different things at different times. So I like my clients to have that match. There are times when it's appropriate for it to be a different person. Like, you have somebody who lives close to you geographically and they are helping you a lot with things, and you want them to be your power of attorney, but they don't need to be involved in distributing things to your family later and all the family drama that may or may not come with that. So there are times, again, this is something that a good attorney is going to discuss with you, not just say, give me a name and I'm going to fill in a blank, but like, who is this person to you? And why are you wanting to name different people? Let's talk about that. And let's come up with a plan that actually is going to be enforceable and not create conflict, right? A lot of us that do estate planning, there's some attorneys, I didn't talk about this in the beginning, so this is sort of like who I am, right? I'm a trust and estates attorney. And there are kind of three or four categories under that. There's estate planning, which is what we're talking about now, coming up with the plan that's going to work. There's probate, the plan, there was no plan, or the plan was not done properly. And so now we're in probate court. There's trust administration. Somebody had a trust, they had a plan, and now we need to carry that plan out. They oftentimes need an attorney because being a trustee is a fiduciary duty, and there are legal requirements to carry that out. You have to give notice to certain people by certain times, and there's a whole thing for paying creditors and settling debts and all of that. There's trust administration, and then there's trust litigation, where you have beneficiaries and they're fighting and there's questions and we don't know what happened. So I do those first three categories: estate planning, probate, and trust administration, and they all inform each other. So it's really great to have an attorney that does probate and trust administration, because when they're doing your plan, they're going to really explain to you why it doesn't make sense to have a different power of attorney and successor trustee, or sometimes this happens very often. I love all my kids and I want to name all of them and I don't want anyone to feel badly. So you need someone who can explain to you why that's probably not a good idea and come up with something that really works. Well, is one of them better at, dealing with doctors and helping or understands medical information and stuff, and the other one's better at, dotting I's and crossing T's and numbers and finance. Okay, well, we can have separate roles there, because being in any one of these roles You may have acted as this person for your parent or loved one or your spouse, um, and you know, or seen somebody go through it, and it's an honor for about 30 seconds, and then it's a huge pain in the behind. It's a lot of work, and it's a fiduciary duty. Like, you can't make mistakes and you can't just do what you want. You have to really understand the document and do it properly. So I say if you think that y- you might actually be showing more warmth and love towards the child or the person you don't name because it's a lot of work. So having these conversations. The power of attorney can kick in two instances. So upon incapacity, or yeah, beyond upon incapacity, I forgot my words there for a minute. So that's generally two doctors saying this individual is incapacitated. Those get attached to the power of attorney. And then when they go to the bank, they talk to Social Security, they talk to the employer, they're making health directions, they're having that proof that you are in fact incapacitated. Alternatively, you can have this document um, kick in immediately. Once it is signed and notarized, that person has the legal authority to act on your behalf. This makes some people nervous, like, oh my gosh, so and so has immediate authority over me. That may feel like a loss of independence, a loss of autonomy. And so that's again something you want to talk about the pros and cons of for your specific situation with your attorney. For a lot of people, it really makes the most sense, especially as we age, because for anybody, we don't know when this event is going to happen where someone's going to need to step in for us. And getting two doctor's notes can be really cumbersome. Sometimes getting that first doctor's note is easy, and people dip in and out of capacity, and they may have a really good, fresh day. And you go to the doctor, and they're like, they're fine. Doctors take that really seriously. Uh, Writing a note saying someone's lost in capacity is, it's a big deal. And so they're very careful about it. And also, that then means that this other person has authority over them. And doctors see a lot of things. They see who's showing up, who's talking for them, who's pushing a particular agenda. And so there's a lot more that goes into it. Um, so if you really trust your key players, right? Maybe your first in line is your spouse, and then you know, it's your kids, and you're like, they're solid, they're not going to do anything, they're doing, a lot of times they're doing all this stuff for me anyway without the power of attorney, they're doing it illegally, but they're doing it. um, then it's maybe less of a risk, and it's more of a benefit, because there may be a day you don't have the bandwidth to spend 3 hours on hold with X bank or X institution, right? And so it's really helpful that your key players and your loved ones can do that on your behalf. So those are kind of the two options, and you really want to look at that. Even if you're doing the state statutory form power of attorney, there is a place to indicate whether it's immediate or upon incapacity, and it can really make a big difference for families, which one you choose. Also, that state form power of attorney, there are a bunch of things like real estate powers, estate planning ability, and there's one to choose all of them, and then you can also select. You have to execute that document properly. Like, you can't just check the box. So you want someone who can advise you on how to even fill out a form. Okay. As we know, I could talk about power of attorney a ton because I have, but I definitely want to leave time for questions. The other big part of an estate plan is the health suite of documents. So an advanced healthcare directive, a HIPAA release, and a directive to physicians if that's what you want. An advanced healthcare directive, I think most people are familiar with this, but it names an agent that can make medical decisions on your behalf if you're not able to do so. Things like whether to operate, whether to medicate, whether to get a second opinion, and then ultimately end of life decision. Okay. A HIPAA release, having a standalone HIPAA release in California is very important. Um, this is who can access your medical records to change doctors, to determine your incapacity, um, and to speak to your doctors. Oops. So we're going to review quickly some of these major players. The person creating the trust, that's you, is known as the settlor or the grantor. Different states use different terms, and it even varies from practitioner to practitioner, but it's the same. It means the same thing. The trustee, executor, personal representative, these are all terms for who's in charge, and the trustee is named in the trust. The executor or personal representative is named when it pertains to a will or to probate court. And the beneficiaries are who will inherit your estate after taxes, debts, and liabilities are paid. All right, what not to do. So this may answer some of your questions. Don't assume your affairs are in order. Talk to a professional licensed in your state. California, if you're in California. Don't add your kids or other family members to house title. So I talked about joint tenancy, like adding your kid to a bank account. But if you, again, people want to avoid this process. They don't want to sit down and have this conversation. They don't want to pay the money. They don't want to take the time to go, you know what? All I got is a house and a bank account. I'm putting my kid on them. Well, this can have major tax consequences. It can change, it will change your property taxes immediately. So that can be really huge. And it will affect capital gains. So you can Google that or talk to your CPA or tax professional about it, but it has irreversible consequences. So do not do that without being well advised. Don't think just because you've added someone as a pay on demand or transfer on death that you don't need to do proper planning. Transfer on death and pay on death accounts get the money where you want when you die, but it doesn't allow someone to access the money while you're alive to take care of you. So I mentioned that before. Very important. I want to mention it again. Don't add someone to your bank account and trust them to distribute your assets after you pass per your wishes. This rarely happens as intended. So, yeah, my best friend knows what I want. I sent her an email. I talk to her about it every Friday at lunch. So, she's going to take care of it. I trust her. Well, the people that are in her ear or that are then taking care of her may not feel the same. So, your lack of planning now will cost your loved ones much more later on. Have your legacy be love, not hassle. Okay, I'm going to stop sharing, take a sip of my tea while we. Is someone going to read me the questions?
It's
Yes.
me.
Okay.
Okay, Bahar, thank you so very much. I'm going to bring my partner on, Jacqueline. Jacqueline, help me out with some of these questions. First of all, Bahar, you did an excellent job of explaining everything, and I truly appreciate it. However, there are a few more questions that people are asking. So, Jacqueline, can you help me, please?
I'm too busy writing down stuff. There
Me
was
too.
so much good
Yeah, I
information.
was right. You saw me writing down stuff too. My head was bending down writing, so I get it. Thank you so very
Oh,
much.
I learned a lot in a very short period of time. Thank you for that. So let's get to someone else's question. I have a My parents' house is in a trust, but has a reverse mortgage. How much time will a heir have to pay it off if the parent dies? I'm not sure if the trust won't go to probate, won't go to
Okay.
court. Sorry, same
hmm
difference.
Well, if they have a trust and there's a reverse mortgage, you have to make sure there's actually the proper deed, making sure that the house is still in the trust. And how long the heir has to pay it off just depends on the contract of the reverse mortgage. So I would call the reverse mortgage company and make sure you understand the terms of the reverse mortgage.
Okay. Question number two. All our legal documents were drawn up in New Jersey and then we moved to California. Do we need to redo everything?
Okay, I just did a probate with this exact situation. Estate laws really vary from state to state. And I had a family, mom and dad and two daughters. Like they literally live up the road from me. The daughters moved to California. The parents eventually followed them out. They bought a house. They sold their house there. They bought a house. Their best friend back in New Jersey was an estate planning attorney. So they had their will, all of that. They didn't know that they needed to update it and to have it comply with California law, and we ended up in probate. So they were so mad. They were like, if we had known, we would have done it. So absolutely, I would go to a California attorney and have them, you know, and talk to them about what it is that you need. And usually attorneys, I'll just be very upfront. Nobody wants to hear this, but they're not going to bless documents from another state. There's something called the full faith and credit clause of the Constitution. So if you happen to, something happened to you before you got a chance to do it, your wishes would be respected, but it doesn't mean you would avoid court. And like if somebody came to me and they had New Jersey documents, I'm not going to like amend those documents. I can't. I'm going to have to create new documents because now you're in a different state and I'm not licensed in New Jersey. So,
Okay.
yes.
I'm going to combine these next two questions. Does the $200,000 threshold include pay on death accounts such as IRA? And is that $200,000 amount for California only?
So, yes, that amount is for California only. It varies from state to state. And there's just only so much I could talk about. But retirement accounts are a special animal because those cannot be named in the trust. They have to be, you have to name a beneficiary on them. So sometimes, excuse me, if you're naming minors, like you're naming minor children, or you're naming, minor grandchildren, you might actually want to name your trust until they're a certain age. You want to talk to your financial advisor and CPA about this because there are different tax consequences based on who you name. But no, the threshold does not apply to tax deferred accounts. So that's IRAs, 401ks, 403bs, other pension plans.
Okay. Two more. The power of attorney is covered by both will or trust, correct?
Pat, will you
I
repeat that,
think I
please?
think they're asking if one power of attorney will cover uh is good for the will or and the trust.
Okay, so the power of attorney is a separate document. These are three different documents: trust,
Right.
will, power of attorney. If you mean the agent, you can name the same person. I didn't mention this, and this might be what this person is thinking, but um, the power of attorney is a document that gives someone authority over you when you were alive. So sometimes people will call me and they say, mom died and she didn't do a will or a trust, but I have a power of attorney and I was her power of attorney. And they're very excited. And I'm like, well, you can't have authority over somebody that's not alive. So it, it doesn't mean anything, actually. Um, so I don't know if that helps that person. But they're three separate documents, and the power of attorney only gives someone authority when you're alive, doesn't help you at all once the person is gone.
Okay. And last question. Is there an advantage to working with a local attorney in the same state rather than someone more distant, uh, either for me or for those that your beneficiaries?
Okay, I'm wondering if
In the
by
same state,
working
rather
with,
than someone more distant online, I'm sorry, either for
oh,
me
I
or
see.
those I leave behind. Sorry about that.
Okay, no problem. So you have to use an attorney that's licensed in the state where you are. Okay. This person, like I work all over California, um, because we do a lot of things via Zoom. Anyway, even people that live are like down the streets. So you Geography within your state is less important. I would not use online services. There are a lot of class action lawsuits against those services, so please be careful. Again, pay now, pay later. It's much more exponentially more expensive. In fact, as an attorney, it's much more lucrative to do probate law because you just the fees are set by court. Somebody I think asked that too, like what the fees are. The fees are set by court. It's a statutory fee that the court decides. It's not the attorney. Those fees that I said earlier, 50,000 and 100,000 examples, that's not me who's saying that's my cost. That is the court that dictates that. And it could be more if it requires more work, but that is like the minimum that any probate is going to cost. So work with someone that's licensed in your state. If your beneficiaries or your trustees are in a different state, that's not a big deal. They're going to contact an attorney in the appropriate place when you're gone or when they need help with it. But you have to use an attorney that's in the state where you are a resident. Where do you pay taxes? But you can definitely use, I mean, someone online that works with you virtually and that's anywhere in your state.
Okay. We could ask a lot more questions, and so many of them you've already answered. What's a POD versus a will, et cetera, et cetera. So I'm going to turn it back over to you, Joyce. Thank you, Behar. This has been really informative.
My pleasure.
Wow, Bahar, like I said earlier, we always having our pencils and paper and electronic devices writing down all kind of good information. So again, thank you so very much for coming. But the good news is we'll see you again at the Piggy Bank Essentials. And then we hope you join us to our next Piggy Bank Essentials. And guess what date that's going to be, everybody? Write it down. Thursday, July the 9th. We'll learn a little bit more about estate planning for the sandwich generation. Aha. Estate planning for the sandwich generation. And if you would like to, again, preview our program that we just completely did a few minutes